Welcome all to Juris North. This is our first hybrid session in person and online. What we do at Juris North, we are several people interested in legal philosophy and political philosophy, and we cut across institutions in the UK. This is a good example. Today we have people in person and online from all over the world, from Brazil to Austria, Italy, and Mexico, to name a few. The idea today, like always with our monthly discussion, we have one expert. Our expert will discuss a topic, will give us a presentation. So thank you very much for being with us. And the rest of us, we are simply people interested in learning from each other. We play a game here. We don't have professors or students. We're entitled to ask any question we want, simply to learn from each other. I have the pleasure today to introduce one of my colleagues and one of the chairs here in Newcastle, our chair in Newcastle for Juris North, Dr. Joshua Howitt, who will chair the complete session. And if we are lucky, we will be joined as well by our chair in Aberdeen, Dr. Peter Cerne. Without anything else from me to say, just a practical thing for the online attendees. The plan is to keep everything in order. If you don't mind, use the chat box at the bottom and let me know if you want to ask a question or introduce a comment later, so I can then feed back to Josh and we keep the order with the questions in person and online. And that's it for me, I think. Josh, I don't think I forget anything else. But again, back to you, Josh.
Lovely, thank you very much, Jorge. It's my real pleasure to host this first hybrid session with Juris North here in Newcastle. I just want to check that I'm not on mute because that's my curse of Zoom. Can you hear us okay, Jorge?
Perfectly fine.
Perfect, good. I cannot wait until this is no longer a problem. But anyway, it's my pleasure to be here, and an even bigger pleasure to welcome Professor Amalia Amaya Navarro to us here in Newcastle. For those of you who are not familiar with Amaya's work, she's apparently British Academy Global Professor at the University of Edinburgh. Prior to this, Amalia has worked at universities across the world and studied in places like Harvard and the University of Europe Institute in Florence. Her work is primarily in legal reasoning and epistemology, and more broadly in the philosophy of law. And she's presently working on a manuscript that seeks to develop virtue jurisprudence with regards to the judicial role in particular. And it's on that topic that she has agreed to speak to us today. So without any further ado, thank you very much, Amalia, for speaking to us. The floor is yours.
Thank you very much, Josh and Jorge, for the invitation. I'm delighted to be here today with you. It's the first time I'm doing this hybrid thing. We are learning so many things with the COVID situation. I like to ask before I start whether there is any camera I should look at or not. Is the camera?
Yeah, we can see you, Amalia.
Okay,
so
okay, so then what I will do is like to speak to the camera as if it were a person. So somehow it's like this Hobbesian, you know. All of you who are in Zoom will be like a Hobbesian. Okay. So thank you very much again. I'm really delighted because I moved to the UK just a few months before COVID hit, so I haven't had as much a chance to visit other universities or interact with academics in other universities in the UK, except by Zoom. And this is I'm really happy to be able to do this in person today, as well as benefiting from the Zoom. And thank you all for attending, both those of you who are here today, as well as those who are participating on the platform. So what I would like to discuss today is I would like to present a model of judicial virtue as expertise. And this is meant to be a part of the book I'm working on at the moment. This is a book on virtue, legal reasoning, and ethics. The idea is mainly to explore the possibility of developing a virtual approach to legal reasoning and judicial ethics. So the first part of the book basically aims at fleshing out a conception of legal reasoning through the lenses of virtue theory. In the second part, I aim to analyze the different virtues or traits of character that are virtues in the context of the judicial role, with a view of showing that from a virtue perspective, both a theory of legal reasoning and a theory of judicial ethics are interlinked. And this is a connection that I think it's difficult to see unless one approaches the subject of legal reasoning through the lenses of virtue. So that is the overall project. But specifically, what I would like to discuss with you today is a piece of this project, which is the conception of the concept of judicial virtue. How would we understand the idea of judicial virtue? And the reason why I think it is important, because even though jurisprudence has been increasingly a paradigm that has increasingly gained some prominence in the field, and several substantive areas of law have been approached through with the tools of virtue theory. Nevertheless, the idea of virtue, the concept of virtue, has not been analyzed, I think, in enough detail. And given that this is the most important, the core concept of virtue jurisprudence, I think it is worth it to aim at developing or engaging in a little bit of conceptual analysis about how the virtues, the concept of virtue can be understood. The main claim of virtue jurisprudence is actually that the notion of virtue, instead of the notion of rules or duties on the one hand, or consequences on the other, should be then made the core concept in the whole architecture of a theory of legal reasoning. So this is why I think it is really critical for the theory for virtue jurisprudence to be a solid alternative to more traditional deontological or consequentialist analysis in legal theory, that it is built upon a solid foundation that is a well-developed concept of virtue. So let me start by differentiating between two, which is not in the handout actually, by differentiating, and then I realized I was put it between two main concepts of virtue. On the one hand, which are discussed in the literature. On the one hand, we have a responsibilist approach to the notion of virtue, that is basically the Aristotelian account according to which the virtues are traits of character. On the other hand, we have a reliabilist account of virtue, which has been used in externalist epistemologies, for instance, according to which virtues are basically capacities. So these are two main trends in the literature, and I'm more interested in the Aristotelian responsibilist approach to virtue. That is the idea that virtues are traits of character. And the reason why I think this is the most interesting approach, or the one I'm more interested in, is because it makes the acquisition and possession of the virtues something that is under our control, so that we are responsible actually for developing. And we can engage in a number of ways in behavior that will lead eventually to the development of virtue. And I think that in the context of the judicial role, this is a very important feature, the fact that it's under our control, that distinguishes it from reliabilist approaches, and it's faceted that one either has or hasn't. And it is because of that I think this is a more promising route to develop an account of judicial virtue. But I want to say at the start that this doesn't mean that reliabilist approaches cannot be useful in other legal contexts. Perhaps not for explaining judicial ethics, but they may play an important role. And I think it's actually quite likely that they play a very important role in other legal contexts, such as legal fact-finding, for instance. So, virtue as a trait of character is a common in fact, a common concept, an ordinary one. So we all know what it means to be honest, or what it means to be magnanimous or generous or courageous. So this is basically this idea of virtue in this Aristotelian responsibility for these traits of character. But beyond that, beyond understanding the virtues as valuable traits of character that are constitutive of human flourishing in the Aristotelian tradition, which is the one I endorse in, and it's also the dominant one in virtue jurisprudence, in fact. What else can we say about the concept of virtue? There are several approaches, several models of virtue in the literature. And it will be interesting to see the advantages and disadvantages of those and the extent to which they can be imported to law. So the first one is the idea is a generalist model. And this is the idea that, according to which, the model according to which the virtuous person is the person who has knowledge of a system of moral principles. That what distinguishes the virtuous from the non-virtuous is in fact the knowledge of a set of principles. However, there is a problem with this conception of even if it is intuitively possible, one might think, there is a problem with this conception of virtue as knowledge of principles. Because one of the main reasons why there is, some people have found it interesting to shift towards virtue jurisprudence or to turn to virtue is precisely the inability of systems of principle to capture right action. So it is because it doesn't seem possible, given the variability of the practical and the fact that there can always be unexpected features, novel features of situation that have not been contemplated when designing and devising the rule. It is because there is always a possibility of exceptions to any rule that it seems necessary to turn to character and virtue in the first place. Because it seems there is no matter how sophisticated and complete a set of principles can be, there is no way in which we can trust that following those principles will always lead us to resolve a case in the best way. So systems of principle, while they are very important, seem not to be sufficient to guide correct action or to capture right action. So it is because of that that we have, meaning we, along with many others who are contributing to the field of virtue jurisprudence, not to mention the very many people who have turned to virtue ethics and virtue epistemology or virtue politics as well, is precisely this inability of principles to exhaust or to give a full account of right action, why we should move to virtue in the first place. And therefore, if we are now to understand virtue possession as the knowledge of a set of principles, then it seems that we are back to where we were in the beginning. It seems less attractive as a project, the project of virtue jurisprudence. So, given that virtue then is non-codifiable, as McDowell and other people, more recently Bridget Clark has persuasively argued, it's the model of the generalist model of virtue seems not to be a good place to start. So this does not mean that principles are not useful, of course, or necessary in virtuous reasoning, and specifically in virtuous legal reasoning. Of course, virtues, the principles are extremely important in any realm, including, of course, and most prominently in law. So the virtuous person is going, and the virtuous judge is obviously going to take very seriously the principles that should govern her or his decision. Principles and rules are also important so far as they aid perception. So they identify some features that typically are relevant in a large number of cases. So there is a point, this is the point of having rules and having principles, that they are extremely useful heuristics as well. And they are also helpful, we see in a moment to acquire the virtues. Oftentimes, in the process of cultivating the virtues, following rules or principles at an early stage of this is particularly important. So this being so, by saying that the generalist model of virtues is not the best way to start, I don't want to undermine or to argue in any way that the principles are not important for virtuous behavior. It's just that we cannot explain all the risks of virtue in terms of following rules or following principles. So what is the second model that we can, another model that we can use that has been defended in virtue ethics, and is perhaps one of the most dominant models, if not the dominant one, which is the perceptual model. And the perceptual model understands virtue as a perceptual capacity. So the idea here is that the virtuous person has, and McDowell has been the person, the philosopher who has most persuasively argued for this model, which has an Aristotelian ground as well. So Aristotle defended the view that the virtuous person perceives the particulars of the case. And it is precisely that perception of the particular of the case which helps the person with the virtues to detect that there is some kind of exception, for instance, in the present case, that is not covered by the rule or by the principle. So the virtuous has not only this knowledge of principles and rules, but also it can be understood as a knowledge of exceptions. And is this perceptual capacity that enables the virtuous person to detect when an exception obtains, or more technically, when there is a divisibility condition with the rigor rule. So that despite the fact that this will be in principle a situation covered by a rule, because of this other feature that the person with the virtue detects as relevant in the particular case, it should not be applied or followed, or it should be reinterpreted the rule, or whatever it is that is not the best way to say this. So this idea of virtue as a perceptual ability, as a perceptual capacity, is an interesting one because it tells us the sense in which the virtuous person goes one step farther than merely following the rules or following the principles. Nonetheless, despite its advantages, I think that there are some problems with this approach to virtue. This understanding of virtue as a perceptual capacity that prevents us from, I think, from finding it a good model for judicial virtue. The first problem that this model has is the problem of that it seems to be at odds with the requirement of as a model for judicial virtue. Is that it seems to be at odds with the requirement of publicity that is important, essential in the legal context. So whatever its merits and some of the problems that this model has, I think, are problems not only for a concept of judicial virtue, but also for a concept of moral virtue elsewhere. So not in the institutional context of the law, but elsewhere. But this specific problem is a problem that is particularly worrisome in the context of legal risk, the problem of publicity, because as we all know, judges and other legal agents have to give reasons for their decisions. It's not that they can merely point out to their own virtue. When justifying a decision, they have to be able to articulate and provide reasons for their decisions. So understanding virtue as a perceptual capacity, as an ability to see into the right, as a higher, as it has been described, order of situational appreciation that does not admit of discursive justification, is in tension with a basic requirement in legal decision making, that is the obligation to give reasons for one's decisions. So this is a problem, I think, a very serious one, not only law, but particularly in law. A second problem that it faces, the problem the perceptual model faces, is a problem that has to do with the phenomenology of judging. So by this I mean, I'm increasingly becoming more interested in phenomenology. I think, well, I come from a strong analytical background, so it's kind of novel to me to discover that I have this inclination and finding it increasingly more interesting and important. But I do think this is an objection that has to be taken seriously as well. Which is the idea is the following. I mean, if we are having a theory, a virtuous approach to the realism, to some extent, this should capture the way in which judges experience adjudication, the way in which they experience the fact of delivering a judgment and reasoning through a case. The perceptual model makes it appear as if one simply intuits what is the best solution, how the case should be solved. So the idea here is that from the view of virtue as a perceptual capacity, apparently deciding cases should be like a very easy thing. You just perceive. So pursuing this analogy between a moral perception and the perception of the empirical sense, the idea would be simply, and actually McDowell uses this metaphor of seeing, simply seeing what is that has to be done. But this seems to be at odds with the phenomenology of judging if we take seriously, as we certainly should take seriously, the reports of people who are in the business of judging, in the business of adjudicating, which is oftentimes extremely difficult, conflicted. So it doesn't come as simply a matter of seeing what needs to be done. So that will be a second reason why the perceptual model, I think, is wanting. And the third, sorry, in addition to the fact that the perceptual model is in tension with publicity and is also in tension with the phenomenology of judging. The third problem is that it makes it a mystery how judges could cultivate the virtues. How it is that one becomes virtuous in the first place. If I am a lawyer in training, I want to become a judge, how it is that I will develop the virtue? It seems that this is the virtue, something like a sixth sense. But either I have it or I don't. And if I don't have it, then what can we do? Here I am, a judge without this very important perceptual capacity that I should have in order to discharge my duties properly. And I don't know how I can acquire in the first place this perceptual capacity. How would we find this perceptual capacity? So it makes it a virtue, something, it makes the theory a bit elitist in the sense that virtue becomes like an asset for a few, but it's unclear how one would, if ever, be part of the club, so to speak, right? So, of the virtues. So, this is also a problem for the perceptual model to provide a good model of judicial virtue. So these are problems that are particularly important in law, but as I said, these are problems that are also applicable in domains other than law, and there are alternatives to this dominant model of perceptual virtue. And the one I would like to argue for is the idea of understanding judicial virtue as by analogy with expertise. So there are in ethics some people who have been arguing for an skill model of virtue. So the idea here most prominently Juliana's in several papers and in a beautiful book, Intelligent Virtue, as well as Matthew's teacher. He's developed as well this idea of virtue as a skill. And I think that this model can provide us some grounding, or we can develop an approach to judicial virtue as expertise, building upon this skill model of virtue, which is meant to be an alternative to both the generalist model and the perceptual model. Okay, so what is the skill model of virtue? So the skill model of virtue defends the idea, is grounded on the idea. I have like far too many papers. The skill model of virtue exploits the analogy or the connections between virtues on the one hand and skills on the other. And the idea that the virtues and the skills are interconnected is in fact an idea that has a long ancestry. So it was defended by the Greeks, but also by the Romans, and also by Chinese virtue theory. So the idea that virtues and skills are importantly connected to one another is an idea that has been there since the origins of the reflection about the virtues in different philosophical traditions. So there are different ways in which it can be understood. In a strong way, saying that virtues are skills, or in a bit more moderate and, in my mind, more plausible way, as an analogy. So there is a structural similarity between virtues and skills that is important in the sense that it is illuminating. It helps us see aspects of the virtue that is difficult to see otherwise. So in ethics, in contemporary ethics, we have people in both camps. So people like Juris who understand skills and virtues as structurally analogous. And the idea is that possessing a virtue is like possessing a practical skill. So the kind of practical reasoning that a virtuous person engages in, the ability to engage in such a reason, is similar, it's analogous in important ways to the skill, to the practical knowledge that one has when one masters a practical skill. That is the idea. Other people go beyond that and identify virtues with the skills, or at least with a subset of the skills. But whether regardless of whether we want, which I don't think it is so relevant for the purposes of the argument I want to make, of whether one goes and defends a stronger or weaker version of the connection between the virtues and the skills, the idea is that we can learn important things about virtue by examining the ways in which the points of similarity between virtues and skills. So on this model, when one possesses a virtue, one possesses not knowledge of a principle, not a specific special perceptual capacity, but rather the kind of practical knowledge that is distinctive of those who master skill. So the knowledge how. Not every skill, of course, will do. So lacing, knowing how to tie up your boots, is a skill. But this is not the type of skill we are interested in when we are trying to figure out what is multi-virtuous reasoning. It's much more complex practical skills, such as, for instance, firefighting. This is one that has been used. So the type of practical knowledge that nurses have when they have, or doctors have when they have to make a diagnosis, or the type of practical knowledge that distinguishes someone who is an expert in one versus one who is not. So in these complex skills, as opposed to simple shoelacing, these are the complex skills that is interesting to compare the virtuous behavior with. Okay, so if we understand then the virtuous person as someone who has the type of practical knowledge that is distinctive of those who master a complex skill, then some of the problems that were besetting the perceptual model disappear from the scene. So it helps us meet these three important objections that I have mentioned in the beginning, and that I think are important before, and I think are important problems or objections that can be raised against the perceptual model. So the first one, if you remember, is reason. The idea that judges who are virtuous are expected to give reasons for their decisions, and this seems to be at odds with the idea that virtue is mostly a perceptual capacity. So if we understand the virtues on a model of expertise, of a practical experts in a practical skill, practical experts, then it becomes interesting the way in which it's not a problem any longer, because experts are able to articulate the reasons for the decisions they make. There is some type of some debate about the extent to which how stringent this articulacy requirement can be understood in order to be psychologically plausible, but we will hardly attribute expertise to someone who, when they tell you, suppose in a scientist, a laboratory, determining when to move one substance out of in the lab, when to transfer one substance to another substance, they just try this sort of say, I don't know, I just know it. I mean, we expect them to actually be able to tell us why, or why this wine is better than this other one, or why we should attempt to stop the fire in this fire building and then go proceed to the next building, or the other way around. So experts are able, when required, to articulate the reasons for their decision. The problem of phenomenology is also, and I think this is particularly interesting, at least to me, now that I'm coming to discover all the interesting phenomenological aspects, I think, of reasoning, which have been interestingly not so much discussed in standard theories of legal reasoning, I believe. And it's that the response of the virtuous person, like the response of an expert, is a response that it is indeed immediate, in the sense that in easy cases, they will have the ability to effortlessly deliver a judgment. Okay, and this is what helps us tell apart, in fact, an expert from a novice. So cases that are extremely difficult for the novice are, to the contrary, easy cases for an expert. So the virtuous person will be able, in fact, to proceed with ease when it comes to the routine cases that he has learned how to solve through experience. But it also allows us to explain the sense in which sometimes the business of judging is actually difficult, and what helps us distinguish an expert from a novice is not the fact that for the expert everything is easy, but rather that when it comes to difficult cases, the expert will have the resources to deal with those cases, whereas the novice will not have those resources to deal with those cases. Okay, so it's not the lack of engagement or the lack of need for deliberation and reflection. Is rather the fact that they have the capacity to engage with these difficult cases that will be impossible to be decided by the non-virtuous or by the non-expert. So it allows us to bring in line, to understand the phenomenology of judging as a combination, on the one hand, of intuitive capacities, but also reflective capacities. When it comes to easy cases, they will proceed with ease and automaticity, but when it comes to difficult cases, we can still account, in line with the phenomenology of judging, account for the fact that sometimes cases will be difficult and require deliberation and engagement, even for those who are experts. And the third problem, the problem of elitism and the problem of virtue being something like a mystery, how we would ever become virtuous. It's also interestingly solved if we understand virtue, judicial virtue, as a matter of expertise. If we understand judicial virtue on a skill model, because there is a substantive amount of literature on how skills are acquired and how one acquires expertise. So there are interesting models that can be transferred to the cultivation of virtue and help us see the way in which we can come to develop this perceptual ability, which is a mark of expertise. So the firefighter sees things that the non-expert firefighter does, and the expert nurse see things that the non-expert nurse doesn't see, but also have these abilities to actually engage deliberation and judgment, and the deliberation when required. And we have these models that tell us the way in which this different set of abilities that are characteristic of expertise are developed. So we have there is this interesting model developed by Dreyfus about the 5 stages to which expertise is built, which can be helpful for understanding the way in which virtue can be cultivated. And it is interesting that rules at the beginning are more important and then less so, as one is more of an expert. And there are also interesting discussions about the possibility of developing and the need to develop expertise through what is called deliberate practice. So the idea that for developing expertise, as much as for developing virtue, one needs to engage in the type of very effective practice that is deliberate practice. It's not a matter of mindless repetition, of automatic repetition or copying. It's rather a matter of self-monitoring, self-regulating one's behavior, being attentive to feedback, having the possibility to receive feedback, and having always this, which Anna refers to as this drive or aspiration to improve, which is distinctive of experts. So experts put themselves always in challenging situations that make them improve and make them better than they are. And this is the route to becoming an expert, and it is also the route to becoming a virtuous person. So the problem of virtual acquisition being mysterious is not a problem for the expertise model either, because we do have these ideas about deliberate practice that have proved to be useful for acquiring practical skills, and models such as the Dreyfus model about how we become through different stages an expert in a practical domain. So to conclude, and maybe I will just mention the last one because I think yes, okay. So then to conclude then with the model, and then I will raise some objection, and hopefully we can discuss that. The virtue as expertise model allow us to put the worries about complexity, phenomenology, and elitism to rest. And it has, in addition, a very important advantage, which is the advantage of being psychologically plausible. This is, I think, important if we want to develop theories of legal reasoning that have an ability to improve the practice. We don't want normative theories of legal reasoning to be so removed from our ordinary ways of reasoning that it becomes difficult for them to guide and orient and improve the practice. So I think psychological plausibility is an important advantage or an important desideratum for any theory of legal reasoning. And the understanding of virtue on a model of expertise increases the claim to psychological plausibility of the theory, because it helps us see the way in which, as we know, reasoning in complex domains about complex problems, like legal problems, combines cognitive processes of system 1 cognition and system 2 cognition. So in this dual cognition models that are like those that are accepted nowadays, of course, this is not the end of cognitive psychology. We will know what we will discover in the future, but for now it's like an accepted theory, this dual cognition theory. We have system one, intuitive, automatic, effortless cognitive processing, and a system two, deliberative, reflective, monitoring the operation of system one cognitive processes. And if we understand virtue in a model of expertise, we can see the way in which virtuous judging, like expertise in general, combines both types of processes. So experts have refined, cultivated intuitions in the domain of expertise, and also alongside these intuitive abilities, they also have reflective and deliberative abilities, as well as meta abilities to detect when one should trust the intuition, or when rather one should revise and revisit and check the extent to which the intuitive response is the correct one. So interestingly, they combine in expertise both types of cognitive processes combined. And if we understand virtues reasoning and virtue on a model of expertise, we are similarly able to explain the way in which virtuous legal reasoning is also integrates both types of system one cognitive processes and system two cognitive processes. So it's not only a matter of deliberation that will be a generalist model of virtue yield such a conclusion. It's not a matter of only of intuition that will be the case if a perceptual model of virtue were accepted. It is rather the successful integration of both types of cognitive processes. So just to conclude, there is a problem which I think can be contracted with understanding virtual model of expertise. And it's that someone might worry that by understanding virtual model of expertise, we are at the end of the day again falling back into the idea that being a virtuous judge or being an expert at judging is a matter of technical expertise. It's a matter of knowing the principles, the rules of legal reasoning, of law, and this is precisely one of the reasons why people are interested in virtue, and I am interested in virtue. The idea that this technical approach to the judicial role is unsatisfactory. So am I not falling back in a position that I tried to supersede in the first place? I don't think so, and I don't think so because legal expertise includes, and this is of course up to debate and will have to be further developed and defended. Legal experts have to be given the moral dimension, and have also to be moral experts. So it's much more than technical mastery that has to be acquired in order to be a legal expert. It's also the type of moral capacities, affective capacities that are necessary to be a moral expert as well. So I leave it here, and I'm looking forward to your questions and the discussion. Thanks a lot.
Thank you very much. Thank you very much, Amalia. Now, as is traditional, we're going to open for questions now. So as Jorge said, if anybody who's attending this seminar via Zoom has any questions, if you could please indicate that in the chat function at the bottom of your screen. I am going to begin by opening to the question rooms here in Newcastle first, just so you can all have time to formulate a response, because I don't know about you, but I've certainly got a lot of things going around in my head that I'd like to ask about. So whilst we're all having a think on Zoom, does anybody in the room want to open us up with a question for Amalia? Lovely. Can I just ask, I'm afraid, the microphone here is really, really insensitive. So if you could take your mask off and speak quite loudly, then hopefully the microphone will pick that up. But Jorge, if you cannot hear the question, let me know and I can repeat it for the benefit of people in Zoom.
Perfect. Thank you very much.
Thank you.
Thanks, and can hear me clear. And hi, can hear me?
Yeah.
Brilliant. Hi, I'm just wondering because traditionally we think being a responsible judge means follow the traditional precedents or follow the rules, which means this is a kind of expertise. But in order to make sure judges are responsible enough and telling whether they follow rules is much easier for us to develop procedures to make sure that they do good jobs. But if we brings moral dimension into this field, it will be harder for us to how we assess judges are responsible enough to be moral judges. Yeah. That's my question.
Okay, thank you. So you worry that by bringing emotions, which is we might not be able to control decisions in this way, right?
Yeah.
Yeah, but I mean, okay. When one introduces virtue as an important concept in a theory of legal reasoning, it's true that one is immediately incorporating the affective dimensions of legal argument, which are there anyway, but we make them vivid and they become an important element in good legal reasoning, because since Aristotle, emotions are virtues are both ways of behaving and ways of feeling. So that in order to possess a virtue, one not only has a disposition to behave in a certain way, but also to feel, to have an appropriate affective response. So that there should be action and emotion should be in agreement in the virtuous person. This, however, I don't think should be a motive of concern when it comes to controlling the reasons why decisions are taken, or in fact, I don't think it impedes the public scrutiny of decisions in any way. To the contrary, it enhances the degree of justification of the decisions. Because if we are to trust, and we should trust cognitive psychologists on this, having the right emotional dispositions is technically valuable. So the person who has certain emotions is able to see things that the person who doesn't have those emotions that do not see, including ways of solving problems. For instance, when one fears, when one has fear, then one sees avenues of escape that the person who is not fearful doesn't see. Similarly, a judge who is indignant at an injustice having been perpetrated might find a way, for instance, of when one has to apply the rule and then the rule gives an absurd result or the wrong result or a very unjust one. Then the judge who feels this indignation that comes with the idea of perpetrating an injustice by deciding according to the interpretation of the rule might find a way of actually engage, and the motivation to engage in a difficult interpretive exercise and come up with a solution to the case that, while respecting the law, perhaps avoids the unjust result. So that can be by means of a more creative or imaginative, more creative interpretation, or employing imagination in ways that allow us to still deliver a legal judgment. So it's not that the reasons backing up the judgment and the reasons that are provided in support of the judgment have to be legal reasons. So it cannot be that the judge says, you know, I think this is just wrong, and I feel bad about perpetrating this injustice, therefore I'm deciding not according to the law, but according to my own rights. That's not the way it should be, of course not. So the reasons will be there, but it will be a richer set of reasons than those that will be available to someone who doesn't have the appropriate affective response. So that is the idea anyway. And it's not raw passions. It's not like just raw emotions and regulated emotions. It's the emotions of virtuous emotions, the emotions of the virtuous person, which are cultivated, self-regulated, etc. So I think they actually enhance, they contribute to judgment as much in law, and they are not an impediment to judgment. in general, and this is true in all domains, including law, of course. And specifically, they need not to be seen as an impediment to reasoning according to the law or justifying, legally justifying decisions. Yeah, it's always a problem though, because I mean, it's always a problem for many people to see the extent to which one could introduce emotions in law, which is like a domain that's foreign to passions. But in fact, I mean, if we think, I think the burden of proof should be rather be on those who deny that emotions play a role, because it will be really strange that emotions play a role in every domain of reasoning, and they contribute to rationality in all domains except in law. No, of course in law as well. Even despite the fact that there are some institutional constraints we have to provide. I hope this is persuasive. Thank you.
Thank you very much for coming, Jared.
I think, Jorge, the fairest way might be if we balance between the room and then to Zoom. So I think it's somebody's turn on Zoom now. So I'll over to you to let that person know who they are.
I have questions myself, but I'm going to stop myself. We have Dr. Isabel Trujillo from Palermo, Italy. Isabel, are you there?
Yes, I'm here. Thank you very much. Thank you, Jorge. Thank you, Amalia. Well, my question, I think that my question has to do with the skill analogy of virtue. And in particular, I want to focus more on the differences than the similarities. But I am not sure that my question is about this. My starting point is that I noticed that you didn't use the term professional virtue or professional skills. Then I was wondering if this is a deliberate choice. You assume something that I want to hear from you about this way of indicating the topic. And I was wondering if the skills that we are speaking of are precisely related to a professional role, and then to science that is at the base of that is the ground of each professional role, and with the obviously the training in that profession. My point here is that science, the professional science, and the professional training could be in some way. I don't believe that this is true, completely true, that they can be, in any case, in some way, they can be morally neutral. And then my question, my question is about this, your choice about not using professional skills or professional virtues, if there is something there, and if this is related to what is missing in the skill analogy. Thank you very much. Sorry for my complex presentation.
No, thank you very much, Isabel, and a pleasure to meet you in person. We've been by email lately often, but so it's my delight. I want to ask you about the morally neutral part, which I didn't quite get. So I believe that one would have this professional training, and it's a training that is professional, morally neutral.
Well, I will say that the neutrality is a hard word, but I was thinking of the possibility of some expertise in some procedures that are perhaps not completely positive, in the sense that the professional training for judges, obviously, but also for all the professionals could be in some parts controversial from the moral point of view. Perhaps I can do an example. Perhaps the problem of the responsibility of judges in their role in Italy, for example, there is a problem with the responsibility of judges when they decide cases, and the people is asking for, I am just summing the problem, the people are asking for judges paying for their mistakes, and obviously there is a problem because a decision is not a mistake if it is given right and wrong to the parts. But you know, this problem is causing a sort of defensive behavior from the point of view of the justification of decisions and so on in judges. And then perhaps a judge is trained to give reasons for defending himself instead of giving reason for the parts. And this kind of training is in some way wrong from the point of view of from the moral point of view, because you know, you as a judge you have to respond, to answer the justice of the case, not to defend yourself for this in this situation. I don't know if I am explaining what I am understanding as moral controversial from the point of view of morality, or you know, negative in some way. I don't know if I explain something better.
Thank you. No, thanks a lot. Thanks a lot. Yeah, I mean, no, I didn't intend to, like, actually, it's surprising that I didn't use at all professional virtue, professional skill. I did talk about judicial virtue and judicial skills, I think, or judicial virtue at any rate, meaning the judicial profession. But it's absolutely, I mean, it's not that I intended not to talk about professional virtues or professional skills. I do think the professional context has some features that make it distinctive, and that is important to, if one wants to develop an account of virtue that works within a specific profession, one should take into account the specific features that are distinctive of in this case, the legal profession. So that wasn't something on purpose at all. Although it might transpire some that the fact that I didn't use it, it might transpire that perhaps that I do think that even though there are distinctive features of professional context that make them different from deciding in non-professional context. Nevertheless, I do advocate, and I'm very strongly committed, in fact, to the view that there is a unity in virtue and a unity in morality, that we cannot divide up the self between the professional self and the non-professional self, or that we cannot divide up the field of virtue or the field of morality into a segmented field of professional moralities, which might or might not be connected with the general morality. Rather, I'm committed to the view that there is a unity in the self and a unity in morality, such that even though there are some specific features of the professional virtues, for instance, versus the general moral virtues, there is a continuity between both sets of virtue. So the idea would be that it is not possible in this account, I think, that one trait of character can be a virtue outside of the professional role, but a vice in a professional role, or the other way around. So it cannot be that being a liar is a virtue if you are a lawyer and a vice elsewhere. That is precluded, I think, from this unitary view of virtue. But nevertheless, I think it is important to realize the extent to which professional the professional roles impose specific constraints, and I like a lot in that sense the specificationist proposal of Christine Swanton, according to which you have general moral virtues that become specified in different ways depending on the professional roles. So professional virtues that in the legal professions, the virtue of honesty, for instance, will not require the same to lawyers than to judges, than to doctors or to nurses. So, that is one way in which the professional virtue ethics would be different, although related to moral virtue ethics in general. And secondly, a point that was raised, I think, but at least the first time I saw it was in Julia Anna's again, is the idea that there are some traits of character that are particularly valuable in a professional context, whereas in other contexts they might be still virtues, but not as valuable. So that, for instance, I mean, if you're a soldier, of course, then courage is possibly a much more important trait of character to have than if you are, I don't know, a priest. Although that depends, right? Depending on the context as well. But so the idea is that the professions will isolate a subset of traits as being particularly important for advancing the ends of the profession, which I agree with you should be justice and not the self-protection of the judge. And the way in which those traits of character are understood is going to be also context sensitive. And the professions will make the case that they should be understood in some ways or specified in some ways and not in other ways. So both the type of character traits and the expression of those traits depend on the professional context. But I think when you mention the responsibility of judges, I think it's interesting that this is a problem not only in the judicial profession, the one you mentioned, but also in others like among doctors, for instance. That they take decisions sometimes not with having in mind the end of health, but rather protecting themselves from all the very many situations that sometimes they have to go through because of the decisions they take. And I think this is an interesting case. I don't know whether this is what you had in mind, but as you were saying, it came to my mind that this might be an interesting case in which it becomes clear the way in which we can structure professional practices in ways that impede virtue, instead of structuring professional practices in ways that promote and foster virtue. So if we make it very easy for judges or for doctors to be exposed to the public, or to be exposed to to professional sanctions, or then we might generate a professional culture and a structure, in fact, the profession in ways that make it less likely that people will display virtuous traits of character, and they would be much more preoccupied by securing themselves than by advancing the ends of the profession. So I think it brings to light some way in which virtues and institutions or professional practices and individuals with the individual virtue are connected to each other. So in order to promote virtue and the skills and professional skills, we need to think not only in ways in which we might want to cultivate the individual virtues, but also ways in which we might devise or design legal institutions and legal professional contexts so that it makes it easier for people to acquire the virtues or to behave virtuously. Thank you.
Thank you so much. Nice to meet you too.
That was a bit too long a response, sorry.
Oh, it's fine. I'm pleased to hear a rallying cry for almost natural law now coming there as well. We need more vocal pushing for that kind of thing. I think it's the turn of the room again now, and Amelia was trying to catch my eye desperately earlier. So over to you, Amelia.
Thank you. First of all, thank you so much for the presentation. Wow, absolutely fascinating. And I've got here about, can you hear me okay, by the way? Can you hear me? Yeah. So my question was, well, I've got several, but the one I chose is the one which relates to your prior work on coherence. And I wondered, how does your prior work, which was very rigorous despite being context sensitive and non-reductionist and non-formal, relates to your claim on, to how would your theory relate to generalist model of virtue and the claim of non-codifiability of virtue? So the idea that virtue cannot be codified. If it cannot be codified, can we at least have a more rigorous account of virtue, one that more coherent, I suppose, against certain non-reductionist logics, maybe deontic logic, or I don't know, model logic, any other form that would offer, so to say, a more rigorous account of virtue that would, allow us to engage with or identify specific traits, perhaps, of a virtuous judge. And you did already identify this two-tier or two-level, several levels expertise, whereby the judge checks on his own expertise and is able to reflect on one's own practice, which already gives us some more rigorous account of what virtue is. But I was very curious about how does your early, very much analytical and coherence-oriented work connects to this claim that we cannot codify virtue, and we now in this, if it makes sense, what I'm asking, do you think that we can pin down, so to say, virtue with more rigorous account, as opposed to just relying on this idea that we are dealing here with a non-reducible, open-ended entity?
Well, thank you very much. This is extremely interesting. It's really the first time I'm asked this question, and it didn't occur to me to see the non-codifiability as posing a problem for coherentism, or how it will be related. When you said that how I would relate this work to the coherence one, my previous work on coherence, I thought you were going more to ask about justification, which drives me crazy, I have to say. So, because I mean, perhaps I should say that the reason why I started working on virtue was not because of virtue ethics, which is probably, I think, it would have been perhaps the most immediate route, like to be interested in virtue ethics and apply it to law. It wasn't really that way. It was because of coherence, in fact. It was because of the fact that by the end of my work on coherence and specifically in epistemology, I came to see that there was no way we could come up with well, at least I couldn't see a way in which we could come up with a way of, with a set of principles that will deliver like the right choice, or that we couldn't come up, or I couldn't come up with any coherentist theory or method that could deliver good answers regardless of the traits of character of the person who was actually employing it. So because of the risk of coherence bias, for instance, if we have a very good coherentist method, whatever it is, as sophisticated as one wants it to be, there is always the possibility that I build up coherence in a kind of crazy way so that it fits with what I want the result to be, or it fits with my inner desires or what have you, right? So that one would suppress elements that were relevant from a coherentist perspective, or one could reason in a coherentist way, in a way that was still compatible with prejudice and bias, and therefore that at the end of the day, the only way to secure the goodness of the outcome was to have a good method, and I still think the coherentist one is a good one, but also to secure that the person who is employing the method has the correct traits of character. So it was that route. There is no golden algorithm, coherentist or otherwise, that can help us, in fact, be sure that if we follow it, then we will get good results. Because there is always the space for employing the method in ways that will prevent us from arriving at good results. So whether this is or not compatible with codification of virtue, I think that it is probably in the same spirit, I think, because virtue cannot be codified in the same way, because I mean, if we want to say that the virtuous response is the correct one, there is no set of principles that I can follow so that they will give me the right result, in the same way in which there is no method of justification that I can follow that will give me the right result. So I think they are very much in spirit. The idea being is both are ways of attacking formalist approaches to reasoning and to agency in general. So I don't think there is a tension, even though, and I think this is perhaps the concern, and I have to think more about that, even though clearly a coherentist method is much more precise than talking about virtue. that is for sure, and it will be interesting whether we could somehow pinpoint the requirements of virtue, and I would be happy to see that work being done in a way that, even though it cannot be like coherence, because it's a very intuitive concept, and there is no way you can actually have all the principles and that's it. As Putnam says, it's like a joke. I mean, there are no rules for jokes, and coherence is equally resistant to being captured in such a way, and virtue, of course, as well. Nevertheless, there are some important things one can say about coherence, and I hope about virtue as well. So it would be desirable to have a more, I wouldn't say formal or rule-based, but definitely a more, less open-ended or more rigorous, as you say. But always with Aristotle's use of advice in mind, that as precise as the matter allows it to be. Well, my own, and I have a sense that when it comes to virtue, an exemplarist approach is probably a way to go. And there is some work being done on what are exemplars, how they qualify, how exemplars relate to those that are not non-exemplary cases. And I have a sense that this might be amenable perhaps to most rigorous analysis, because it has been done in philosophy of science than other approaches to virtue that do not focus so much on exemplarity, but that will need to be done, definitely. But thank you so much. This is very interesting.
Another collaborative project born from Juris North right there, live in the flesh. I think we'll go back into cyberspace now. Well, here's
thank you, George. We have quite a few questions from here, so I'll try to be very brief. Before Richard, let me welcome Dr. Peter Cerne, our chair in Aberdeen, and he's one of our founding members. Together with Veronica, we were, and Mike, and William Lucy as well. So welcome, Peter from Aberdeen. Now, Richard Mullender here in England. Richard, your floor.
Thank you. What I have to say, I think in quite a number of ways connects with points that Amelia was just making. Obviously, I think to try and codify virtue would be rather unwise. So see what I'm saying now as more of an exercise in ostensive definition. And it seemed to me someone who's helpful here is Ronald Dworkin. If you think of his idealized Judge Hercules, it seems to me that he presents us with a judge who, when he examines institutional history, is strongly committed to close reading. That's a virtue. This judge is also committed to reflection on institutional history. That seems to be a virtue. There is an effort to extract from the history that's reflected upon propositional content and to frame it aptly. I think that calls for a certain type of virtue. And then an effort to systematize the law that emerges from the process. All of these aspects of the work that Dworkin describes, it seems to me, connect up with virtue, and if you like, an aspirational understanding of law, which has affinities with Lon Fuller's account of the morality of aspiration at work within law. But it seems to me that alongside those rather active virtues, there are a number of other points that could be made, and here I'm going to refer to another American reference point. Alexander Bickel famously wrote on what he described as the passive virtues, and what he has in mind, among other things, there would be difficulties with the ability of judges to process cases, if you like, the issue of non-justiciability. So judges have to be alive simultaneously to what law realistically can do. And it seems to me when they're doing that, they've got to get the objects of their attention clearly into focus. And then they've got to be able to articulate apt responses, not simply by finding propositions which make sense, but also thinking about propositions in the context of a particular system. One thinks here, for example, of the European Court of Human Rights with its emphasis on the margin of appreciation. You know, particular cultures encourage the articulation of the law in particular ways attuned to those cultures. So all of these are rather active dimensions of what judges do, but there comes a moment when they have to say, if you like, thus far and no further. We can't sort of stray into areas that are beyond our competence. And it seems to me virtue attends pretty well everything I've said there.
Thank you, Richard, for the question. I have to disagree, I think, with Hercules. Actually, I had a paper that was never, you know, one of those papers that stay in the drawer and never gets written, about why, in fact, why Hercules is not a virtuous judge. That was that was what the paper was about, and never got around to write it, in fact. So despite the fact that I admire a lot, of course, Dworkin's work, and I find Hercules inspirational in an important way. And I do agree with you that the sum of the skills that you mentioned would be virtuous, such as being committed to institutional history or the capacity to systematize the law. That will definitely, I think, be important virtues in a skills in a virtuous judge. Nevertheless, I think there are some reasons why understanding by using ostentation, like say, well, this is what virtue is, which is basically what I was trying to respond instead of having like rules, having more an exemplarist approach. So saying this is the virtuous person is that, right? Or this would one good example of a virtuous person. But I wouldn't pick Hercules as my exemplar. And the reason why I wouldn't is at least two reasons why. The first one is because Hercules is constrained by principles, is principle-based. His judging style that in a way or to an extent that is probably inimical to virtuous reasoning, which is much less grounded in rules and principles than Hercules' reasoning style would. So I think this is one aspect that differentiates Hercules' type of reasoning from a virtuous type of reasoning. So that there are all these very important, I think, perceptual capacities in virtuous reasoning. Also pregnant the perceptions that are how they are called hot perceptions, in the sense that they are pregnant with affective dimensions and emotions in general. And this is I mentioned that this perceptual and emotional dimensions are, I think, at least not sufficiently highlighted in Hercules' reasoning processes. So, and to the extent that this is so, I think it will not be a good exemplar of what virtuous reasoning is.
Could I very briefly make a couple of points in response to that? One is, it seems to me that one should set Hercules in the context of, if you like, the wider Dworkinian contribution. So, for example, in Law's Empire, he talks about the purer form of law beyond the law that we have. So I think if one accepts that any judge in any actually existing non-ideal jurisdiction is cabined by the limits of the jurisdiction, I think Dworkin is saying that lying beyond that is a body of law that would better approximate to ideal theory. And just one further point that grew out of your final observation there, it seems to me that the reflective processes that you're describing are ones that intersect with what Charles Taylor says in his book, The Language Animal, about Herder on reflection. So Herder talks very influentially about Besonnenheit, and makes precisely that point, that we are embedded in forms of life that are rich in significance, and it's a taxing, sometimes wearying process to draw that significance out and think about its practical implications in actually existing context. So I think Charles Taylor could be a really fruitful reference point if I've heard you right there.
Yes, thank you so much. Yeah, Taylor is in my top list. So I can see that I have to immerse myself and in his work, and I greatly appreciate the suggestion. Absolutely. There was, I mean, I understand the difference between the more pure integrity or the inclusive integrity and the extent to which the fact that we have to attend and judges have to attend to the constraints, and Dworkin is very attentive to that. But I don't think that this will still exclude the fact that the judges, virtuous judges, will need to engage in perception and affection in a way which is maybe Dworkin that have that in mind as well. I mean, in the sense that he will not be able to define his principles in light of the novelty of the cases in the way in which he does, unless he has those perceptions and emotions. But yeah, but they are not highlighted to the same extent, I think, and I think that that would be one difference. But there was something else I wanted to say in response to your previous comment on Hercules being an exemplar, which is, and this is perhaps a more is closer to my heart, so to say, than the point about perception and emotion, that I can somehow reconcile. I can accept what you say about the difference between the more institutional integrity or pure integrity. I don't quite remember exactly the names of those. I think it was pure versus. If someone remembers, pure versus inclusive, I think it was. Well, which is the idea that Hercules is highly idealized in a way in which it is not a type of normative idealization that is at work in virtue ethics or virtue jurisprudence in general. In that Hercules has capacities that judges, no matter how virtuous, cannot have. And I think this sets him apart from the phronetic judge, or from the Spodaios, if you want. I mean, from being an exemplar of a virtuous judge. Because one of the things that I don't know about other people working in virtue jurisprudence, but in my case, one of the reasons why I find this attractive, I mean the virtue jurisprudence attractive, is because it puts forward a normative ideal that drives us to that inspires and drives us to aspire to do better than we do with the resources we have. And I think this is a very attractive normative ideal, in contrast to other ways of doing normative theory that assume capacities that are so far beyond what the cognitive and memory resources we have, that it is difficult for me to see the way in which they could help us regulate behavior and improve the way we do things. And I think this is something, this high degree of idealization that is present in Hercules, despite the fact that Working is very aware of the fact that there are constraints in normal judges and all that. I think this is puts Hercules along with, I don't know, impartial spectators and all those devices in the history of philosophy that are extremely idealized and different from the virtuous person.
I mean, just very briefly, because I don't want to take up too much time. This will be.
I was going to say, Richard, if we could keep this really brief, I'm afraid.
Absolutely. It sounds as though the difference between the Dworkin position and your own is the difference between an extravagantly idealized judge whose raison d'etre, if you like, is to bring out the features of an ideal theory, as against non-ideal judges working in non-ideal contexts. I mean, that does seem to capture, if you like, the divergence of view between us on Dworkin, and that makes complete sense to me.
Yes, thanks a lot. Yes, I do think ideal, non-ideal definitely would be a great use in this context. Thanks a lot.
Thank you, Richard. Sorry for being a bit assertive there. Amalia, we're approaching kind of the end time, but I think Jorge said there's been a lot of questions on the chat. Are you okay to keep going for a bit longer?
Yes, of course.
Brilliant. In that case, Jorge, I think Tomas and Lucas, you said, have been waiting patiently for quite some time.
Thank you very much. Yes, we have Tomas. I'm going to read on his behalf because his microphone is not working. Tomas Widlak from Gdansk, Poland. I think you met him, Amalia. He has a question here. Let me read. Is there a way to define the proportion between virtues as innate predispositions that are necessary as the starting conditions for judging, and virtues as skills that can be developed? In other words, in the personal qualities of a mature, virtuous judge, does virtue understood as a trained skill definitely outweigh moral and intellectual predispositions? Thank you. That was from Tomasz from Poland.
Yes, thank you, Thomas, for your question, and Jorge for reading it. Definitely, I think the relevant understanding of judicial virtue will be those virtues that are as acquired, as trained, that are the result of training, and a conscious, well, not only conscious, but it does involve some self-reflection process of acquisition of traits. And I guess, so this will distinguish it since Aristotle, the idea of virtue from natural virtue, so that the very young will not be virtuous in Aristotle's view just because they didn't have the experience and actually couldn't acquire those traits of character regardless of what the innate capacities they might have had. And I think it is important to stick to this idea of virtues as acquired traits of character, because in the beginning of my talk, I I indicated the extent to which I think responsibilism about virtue is more interesting than reliabilism, precisely because we are responsible for developing them. So if we tie up an idea of virtue as an innate capacity of intellectual, the satisfaction of some intellectual requirements, then the problem becomes that we are not responsible, or not to the same extent, because these are the capacities we have, right? Nonetheless, I read your question as perhaps indicating, which I think is right, in fact, that by talking about expertise, I'm leaning towards giving a role to the innate capacities or intellectual abilities more than that will play a bigger role than in other conceptions of virtue. And this is an important worry, I think. In fact, some defendants, some proponents of skill models of virtue have aimed at distancing themselves from Julia Anna's approach to the analogy between virtue and skill, because they think it's over-intellectualized and it gives too much role to the capacity to, for instance, articulate reasons. And it puts too much of an emphasis on reflective capacities and intellectual capacities, and to the extent that it does so, it will be more connected to innate abilities than to acquired traits. However, I think this need not be in that way. And in fact, empirical work in expertise is pretty conclusive in this respect, that in almost all domains of practical expertise, the level of expertise really is the result of the expert performance is disproportionately the result of experience and training versus innate capacity. So, and there is actually a very substantial body of research targeting the extent to which innate abilities are or are not responsible for being able to achieve high levels of expertise, or reach, be able to engage in excellent performance. And it is, I think, interesting that despite all these efforts to refute the role that experience and training play, nevertheless, so far, the empirical research is telling in this respect that the key to expertise is really practice, not simply accumulating hours of practice, but this deliberate practice, this practice that is monitored and self-reflected, etc. This is still the key to reaching expert performance, and I think also the key to cultivating, to acquiring the traits of character that are virtues.
Thank you. And then Lucas, you've been waiting so patiently. Thank you. Thank you so much.
No, that's okay. Can you hear me well?
Absolutely.
Thank you. So I'm talking here from the southwest part of Brazil. So it's a long way, but the internet is closing us together. And that's quite an honor to be here listening to Professor Amaya lecture. And my question is a little bit the same as the coherence question, but I would like to try to bring it to a Brazilian context in our Supreme Court that is has a kind of activist approach to social issues as public policies of healthcare, schooling, and more recently, COVID-19 management, public management, controlling issues and political movements. So here we have one of our Supreme judges, that is Ministro Barroso, for those that acknowledge him, has an idea of a judicial activity that is based on virtue, that is guided by three main guidelines. One, the Illuminist guideline, that is the Supreme Court has a duty to move the wheel of history through Brazilian society. A second one, that it's a contra-majoritarian one, inserted in a constitutional way. And the third one, it's a representative one, not quite close as Alex's representative constitutional approach through argumentation, but is a representative approach due to a lack of representativeness from the legislative body. So in facing these three guidelines of an approach of judicial virtue by decisions, I would like to question Professor Amaya in a way addressing to Professors Richard mentioned, to Dworkin and to Alexander Bickel, if we can have a certain scrutiny that can be done in a positive virtue approach and a coherent virtue approach in terms of an institutional history of decisions of Supreme Courts and other courts, and to try to make a diagnosis of what's happening in activists and courts, that it's mainly a big issue here in Latin America, and of course in European human courts and throughout the world. But here in America Latina, Latin America, we have a big issue with these political encouraged judges that give us a real fight between executive power and judiciary power. So thank you very much for the time and the space, and I'm really hope that my question is clear and that my English is a little bit rusty.
Thanks a lot, Lucas. I mean, I'm conscious of the problems with judicial activism in Latin America. I am in Edinburgh since 2019, but before that, I mean, and I am still, my permanent position is in Mexico. So, and we do face in the Supreme Court in Mexico and in Mexican culture a similar problem. So I understand where the concern comes from. I am not that clear about how to respond to the problem, though. But let me perhaps only say that, and my response perhaps with coherence and virtue is similar in that respect, perhaps. Although again, I mean, thank you both of you for pressing me on that, because I haven't really think so much about how to connect the two parts of my own research. Like it felt to me like I did one thing, finished, now I'll do another thing. But of course, I mean, there is a lot to be said about how these two actually combine, and I should make an effort to clarify that much more.
Sorry, can I make an amendment just to clarify my position? Here in Brazil, I'm quite a reader of Professor Amaya work, and also here in Brazil we have a quite of a small core of students of these kinds of issues, and a conjunction that I do a lot is McCormick's idea of a good way of life guiding material form of scrutiny in judicial decisions, that it's submitted to a coherence scrutiny. And here in Brazil, we have a civil law, as do Mexico, a culture, and hence the work of Theodor Vierweg, Topic and Jurisprudence in that Romanist approach, close to a prudential Romanist, antique Romanist approach, is quite helpful, I think, in terms of bringing together the topic prudential approach that it's brought to a matter of virtue and materialist justice in cases, and also to the building, to the construction of historical institutional coherence, in those terms that I would like to address.
Yes, no, it's a big problem not only in Latin America but also elsewhere, but particularly at the level of the Supreme Court decision. But the one you mentioned. And coherentism is, of course, it is a conservative approach in the sense that it has to respond to the intellect, to the historical, to the institutional history. But I think it has the resources within the theory not to necessarily favor always systematically even repeating mistakes, for instance. But to the contrary, I mean, because of reasons from coherence, if one understands the set of reasons that have to be made coherent in a broad sense, moral reasons, for instance, might be so weighty and so large, play such a large role within the whole set that might displace respect for institutional history and then justify this type of judicial activism that is nevertheless a concern sometimes. However, and this is why I think these are the limits of coherentism in a way. At the end of the day, it's going to be up to the judges to determine which are the reasons that have to be brought into the set and how those, among the different ways in which they can be made coherent, which is the way that I'm going to favor. There is an interesting in Scotland, an interesting contribution of in Scotland to geological, to the history of geology, in fact. Very interestingly, the whole understanding that was an inspiration for Darwin, which is not a minor thing, of understanding the Earth as an evolving mechanism, as an evolving system, came from a mismatch and incoherence between evidence and theory. And then some people decided, and it was a schism in the geological landscape, some people decided not to pay attention to the observations and shed doubts on the observations that were made. The other people decided not to preserve the theory, but rather upset the theory in light of the new observations. So there are several ways in which a system can be made coherent, and similarly for judges, reasons, moral reasons can upset institutional history. Institutional history might be preserved at the cost of sacrificing moral reasons. I don't know whether that is clear. I think the history of geology is amazing, extremely interesting, because it clearly clarifies the sense in which one can take, coherence does not give you the last word, in the sense that there might be different ways in which the set can be made coherent. And this is why I think that traits of character are relevant when it comes to deploying the method properly. This does not mean to say that the moment I introduce virtue as a complement to a coherentist method, it is going to be tied up or clearly tell me whether I should go for a more activist approach or I should go for a less activist approach. Virtue is not going to tell you that, because it is going precisely one of the advantages of virtue, which might come of the lack of rigor, I accept, is that it is context sensitive in the sense that there is no single recipe that when you face this conflict, then you should go for the judicial, just engage in judicial activism, or you should not. It's going to depend on a number of features, of contextual features that will vary the variability of the practical that I mentioned in the beginning. So one of the ways in which this is more clear, I think, is with the virtue of judicial humility, which is one that I have been particularly interested in. The humble judge is not necessarily the judge who differs and is not an activist judge. It's going to depend. It's going to depend on the case, it's going to depend on what is at stake, and it is going to depend at the end of the day on the judgment of phronesis. So it's not that one specific virtue will always issue into political judicial activism or not, because at the end we are not aspiring to judge as a humble judge would, but as a virtuous one would. And this means judging as someone who has humility, but also generosity, but also a sense of justice, etc. So I hope, I understand that this is vague and perhaps not unsatisfactory, because it's not that a virtuous approach will tell you always favor judicial activism or always put a stop to this Supreme Courts that are trying to overreach. Unfortunately, things are not that simple. But this is why we need the virtues in the first place.
Perfectly. Yes, it does. Thank you very much, Professor.
And with that, I'm afraid I do think we need to start wrapping this session up. I just want to say how impressed I am actually that neither Jorge nor myself have abused chair's privilege at any point and interjected with our own questions. I know I've certainly got several, but I'd like to thank everybody both in the room and also virtually for attending our talk today. I think the questions that we've had have all been really rigorous and insightful, but then that's to be expected given the paper that we were given was also incredibly interesting, rigorous and insightful too. So if we could all show our appreciation to Professor Amaya, I think we should do that in a traditional way. So thank you for joining us today in person in Newcastle. That's it from the room. Jorge, I don't know if you had anything to say about the next Juris North events that were coming up.
Very briefly, first of all, thank you, Amalia, and all the attendees, because this is our first hybrid session, so it's been a pleasure. Josh and Newcastle Law School, thank you very much for a wonderful organization. And in particular to all the chairs. We have today Peter from Aberdeen, again, Veronica, Mike, William, Anna, and Chris, because they tend to see my email, or right now Josh's face. But we are quite a few people, you know, bringing together Juris North, and I think that's why we've been working together for so long, because we are here, you know, regardless of our egos or personal academic careers, we want to bring something together. So thank you very, very much, and I think today we proved that. Next academic year, no, next year actually, 2022, we have, for the first time in Juris North, events in Portuguese and Spanish. We'll be talking about Kelsen from Latin America. So we're inviting, and this news will come very soon. I think next week when we share the video from today, we will have sessions in Portuguese and Latin America with chairs from Brazil, Lucas Mioto, from Argentina, National University of La Plata and Buenos Aires University, Juan Pablo Moreso and Isabel, someone else from Instituto Tarello in Italy, well, and other colleagues as well, and from Mexico, the university, the Autonomous University of Mexico, we will be a few people together, and a set of other roundtables about sustainability, political sciences, with other colleagues, and the open call for monthly discussion as always. And because of Josh, Peter, myself, and all the others, we are bringing the session hopefully online, face-to-face, or hybrid like today. And I think that's it for me. Am I missing anything, Josh?
I don't think so, Jorge. Just to wish everybody a happy Christmas and New Year, I suppose, as well. And thank you again to Professor Amaya for
Thank you all of you. Thank you all of you. Thanks a lot for all the questions today and for the invitation to share the work here. Thanks a lot.
Thank you. Stay safe, everyone.